Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I hope you guys are having an amazing evening. I don't know if you guys heard, but YNW Melly actually filed a writ of habeas corpus in state of Florida against the Broward County Sheriff's Department. Let's dive right on into it. This petition was actually filed yesterday, which is very interesting, but not so interesting because you could file any day of the week. So this, as you can see, is United States District Court, Southern District of Florida, Miami Division, and you have Mr. Jamell Demons, crazy last name, versus Gregory Tony, Sheriff of Broward County, and the Broward County Sheriff's Office. Now, I am not so much into entertainment. It's just basically what I will see if I'm scrolling on social media or in the YouTube streets, but I'm not really into celebrity business. And I know that sounds crazy because it's like, okay, you sit here and you read these petitions. That is correct. But that outside of that, I'm all about my business, my kids, and my household. So I don't know exactly what is that he is currently incarcerated for, but he has filed a petition for a writ of habeas corpus, which just kind of means, and as I explained in the Tory Lane situation, they just feel that one, they're requesting a hearing before the judge to explain why they are being unlawfully detained or why them being incarcerated is not legal. And so he has filed this, and we could just hop right on into it. So it says the petitioner Jamell Demons by and through his undersigned counsel petitions this court for a writ of habeas corpus pursuant to the Title 28 of the United States Code, Section 2241, asking the respondents to appear and show cause why Jamell Demons should not be immediately released from custody for rigorous violations of the United States Constitution. In support thereof, petitioner states the following. So y'all been with me for a while, so you already know that the petitioner and the plaintiff had burden of proof. This first paragraph is just pretty much stating that the court should order for these respondents here, Tony, the sheriff of Broward County, as well as Broward County Sheriff's Office, to appear before court and just pretty much like they need to say the reason as to why should he remain in jail. So that is what it's asking. So but let's go into this and see what's going on. All right, so the intro says petitioner Jamell Demons seek his immediate release before he because he is being illegally detained under conditions that violate the First, the Fifth, the Sixth, the Eighth, and the 14th Amendments to the United States Constitution. Demons is a black male whose current detention conditions shock the conscious and could not even be imagined in this day and age, even in a third world country that has no guardrails protecting human decency and dignity. So that means that his conditions right now is not looking too good. Oh my gosh. And so it's going to explain. Like I said, I'm with you guys. If you haven't been following this, we all trying to figure out what's going on. It says for over 3 years, petitioner Jamell Demons has not been permitted to make a single phone call or have a single visit with his family or any member of the outside world, including not seeing or speaking with his own mother in over 3 years. Demons has and continues to be subjected the type of deliberating isolation that renders his conditions of incarceration cruel, unusual, and beyond belief in a civilized society governed by the constitutional safeguards. He has also had restrictions placed by detention officials designed to impede his interactions with his attorneys and his ability to prepare for trial on capital unaliving charges. His cruel treatment by the Broward detention authorities warrants his immediate release from pretrial detention since the detaining authorities have shown such a callous disregard for his human dignity, right to counsel. Oh, that's a lot to unpack. So he hasn't spoke to his mother or anybody in over 3 years. They are keeping him incarcerated in a cruel, unusual manner, which is crazy. I wonder if they gonna go into details as far as his living conditions are. I have not been to Broward, so I don't know what the jail conditions or the county conditions are. But this is crazy. Everybody that they say, are is proven innocent before, they're proven guilty. Um or innocent before proven guilty. I totally messed that up. But he does have the right to all of these things. Like, why hasn't he been able to contact anybody? Why are y'all not allowing him to speak, with his counsel? So some things is not too good right now. He has been in custody since February of 2019. It is November 3rd, 2024. This is sad. This is really sad. Sheriff Gregory Tony is the sheriff for the Broward County and responsible for the humane treatment and overall conditions of inmates in Broward County detention facilities that is operated by the Broward Sheriff's Office. I'm just convinced that no county detention facility is good because here in Dallas, Lutz there, if everybody knows that, I sat in a criminal courtroom when I was doing the Jaguar White when I was waiting for her to show up in court and overheard a incarcerated female tell us the conditions about the facility, like rats are eating through the breads and the tortillas. What? I mean, I understand that they committed a crime and they're doing their time, but at least, like, you have to have some type of decency for them to be treated as humans. They are humans, you know what I'm saying? Wild. All right, so let's see. Background. Petitioner was arrested on February 13th, 2019, and has been in continuous custody since that date. He proceeded to jury trial, but the judge declared a mistrial in July 21st, 2023, when the jury was not able to convict him. In October 2023, Broward Circuit Court Judge John Murphy granted the petitioner's motion to disqualify the state prosecutor in a motion contending the state attorney withheld evidence. A new set of prosecutors have come on and have done everything in their power to delay the trial from commencing. The case is currently stayed pending a ruling on an appeal taken by the state attorney. Meanwhile, the plaintiff, who remains in custody since February 2019, is continuously abused and denied bond. The petitioner has not been permitted phone or in person or any type of visitation with his family, including his mother, for over 3 years. In addition, respondents have placed unreasonable restrictions and interfered with his ability of his attorneys to interact with him. This has included forcing his attorneys to wait for hours to see him, not letting them see him at all, and forcing them to meet with him in conditions that interfere with and impede the privacy and privileged nature of his communications with his lawyers. And that is true. That's what, and like we see on the movies as well. When an attorney comes, they have a right to go into a separate room and speak to their clients. That's attorney client confidentiality. On or around late April 11, 2022, inmate Jamal Myers filed a grievance report in retaliation of the plaintiff's refusal to purchase him food from commissary. Inmate Myers filed a grievance report against not only plaintiff but another inmate. Inmate Myers alleged in part that Mr. Demons was planning an escape by having his attorney bring in two handcuff keys in aid keys to aid in the escape. Mr. Demons employs multiple criminal and civil attorneys. In response, correction personnel conducted a shakedown of plaintiff's cell and the other inmate's cell. In accordance with certain supplemental investigation report, the shakedown of plaintiff's cell unearthed commissary and excessive jail issued clothes, which were confiscated and disposed of as per operational orders of the jail. It- so boy had a lot of commissary and a lot of clothes that he was supposed to have. However, the other inmate on the dorm was found in possession of shanks, prescription drugs, or drugs, and other contraband. The inmate was subsequently charged for his possession of contraband. So that pretty much backfired on him. So he tried to tell on YNW Melly, well, lie, and he ended up getting busted. Yeah, see what happens? Plaintiff was found to have committed no wrongdoing, and the investigation closed as to the plaintiff on April 11, 2022. Despite no wrong of the let me see. I'm sorry. Despite doing no wrong, the plaintiff was moved from his current dorm into solitary confinement, and all phone communication with the outside world ceased. Shortly thereafter, two of plaintiff's defense counsels attempted to visit him and were not allowed entry into the jail facilities. The facility refused to provide any reason as to the denial. The following day, attorney Stuart Adelstein made an tennis motion regarding the jail's interference with the plaintiff's right to counsel. Honorable Judge Andrew Siegel summoned Broward Sheriff's Office Attorney Christian Stubis to court. Attorney Stubis defended the actions of the facility, stating there was an open investigation against Mr. Demas and further that he was a threat to the security of the jail because he was alleged by Attorney Tubis to have been found with a shank in his dorm. Now, that's crazy because they just said that the other inmate that was trying to get Mr. Demas in trouble was lying and got caught with that. And the case against, YNW Nelly was closed. 18 says attorney Adelstein inquired if any of Mr. Demas' defense team were at that time or ever under investigation. Attorney Subis responded no. Judge Andrew Siegel instructed Attorney Subis that the jail could not restrict the plaintiff's contact with his attorneys, and Attorney Subis would have to come up with effectuate plaintiff's visits with his attorneys. As a result, plaintiff's visitation took place in a visitation booth located downstairs in the bond room. The visitation booth did not accommodate Mr. Demons and his defense team in one setting. Moreover, it was impossible to review any documentation with Mr. Demons due to the plexiglass divider. Not only was the visitation room not large enough to accommodate defendant's attorneys, but anyone also standing outside of the room could hear everything that is said in the room, violating defendant's right to private and privileged communications. On September 7, 2022, attorney Raven Liberty filed a motion to remove visitation communications or interaction restrictions. Prior to the hearing on the motion, attorney Raven Liberty contacted Christian Subis in an effort to reach a resolution without hearing. Instead, Raven Liberty was met with unhinged screaming from the BSO attorney, questioning her about what do you talk about? What do you spend so much time with him? Or why? Christian Subis ended the conversation in telling attorney Raven Liberty that if she went forward with the hearing, he would embarrass her. Boy, Florida's doing this. It is important to note that plaintiff's defense team was not in possession of the incident report, so that the defense team and the court all relied on Mr. Subis' proffers to the court that have not been determined to be untruthful. Despite the believable threat of character assassination, Raven Liberty proceeded to hearing on the motion. Christian Subis ranted, and I'm probably saying his name wrong, but I'm so sorry, ranted and raved about unverified allegations and the behavior of the plaintiff. Despite Christian Subis' attempts to not only embarrass attorney Raven Liberty, he failed. Subis was instructed to accommodate visitation between plaintiffs and his attorneys with that was free of third party being able to listen. So pretty much the court sided with YNW Melly's attorneys and say, okay, you have nothing, absolutely no reason to not allow him phone calls, visit him being able to sit down and communicate with his attorney. On September 29, 2022, Raven Liberty was contacted by a reporter for an online media outlet and informed that an unknown member of the BSO contacted them, led them to believe she was the attorney that the inmate Myers was speaking about in his unfounded grievance. As a result of the accusations of the Broward Sheriff's Office, story ran for weeks about the alleged nefarious escape plan between Raven Liberty and the plaintiff. So, wow, Broward County Sheriff's Office. So we out here lying? We're out here lying. They found that none of this was true. And he's still sheriff. I have to go look at this. The escape plan created by Broward Sheriff's Office was not the worst of it. December 1st, 2022, under the charge of Captain Hubert, plaintiff without cause was moved to a unit inside the jail that is meant to accommodate 24 inmates. Plaintiff was the only housed on that vacant unit with no privileges, no TV, no access to to a newspaper. When plaintiff was allowed his hour out of the cell, all other inmates had to go back inside their cells. Specifically, during December 2022, Lieutenant John Baptiste, along with Sergeant Anthony Kidd, threatened plaintiff if he told his attorneys about his treatment, they would hide him away from the world. Plaintiff has not had phone privileges since May 8, 2022. The plaintiff has not had private visitations with his defense team since March 2022. As recently, without reason, plaintiff was moved to the Paul Rand Detention Center and housed on a floor with no one else. His door had been removed from his cell, preventing any privacy, and he had a member of the emergency response team shadowing him 24 hours a day. They were instructed not to speak to him. Plaintiff went without any human contact for several months until again Broward Sheriff's Office moved him. Now this is sad. Florida Statute 901.24 states that a person arrested shall be allowed to consult with any attorney entitled to practice in this state alone and in private at the place of custody as often and for such periods of time as is reasonable. The ongoing denial of Mr. Demon's access to his attorneys is not only preventing Mr. Demon's attorneys from properly preparing Mr. Demon's defense, but is in violation of not only his Sixth Amendment rights, but Florida law as well. In order to punish and isolate demons, the respondents have isolated him and not permitted a single phone call or visit from family in over 3 years. The isolation has inflicted enormous emotional impact on him and is designed to deteriorate his mental health and his ability to prepare for a trial that is now scheduled in September 2025. Oh my gosh. These restrictions are not for security reasons and bear no rational relationship to any legitimate secret interests. The respondents monitor the custody of thousands of inmates and have never imposed such restrictions. No non Black inmates currently have any such punitive restrictions. Grounds for petition. Ground 1. The respondent has illegally and improperly violated petitioner's constitutional guaranteed right to counsel and his ability to prepare for trial. These actions have been done with no due process and bearing no relational relationship to any legitimate state interest. Thus, he is being illegally detained in violation of the Constitution of the United States. Ground 2. The respondent is being illegally detained under conditions that are and unusual and that not only bear no rational relationship to any legitimate state interest but violate the petitioner rights to due process and equal protection. Exhaustion of remedies. On September 7, 2022, and other dates, petitioner has continuously sought relief in state court, which relief has been useless. Bringing these constitution deprivations to the attention of this state court and state authorities has not provided any relief. So he has brought this to attention several times and nothing has been done. I'm very interested on what the court is going to do in regards to this, and I hope that they have evidence, but the way that some of these, especially these counties, you can't trust these county facilities. You really can't, because it's going to be their word against your word. It's not like he has any witnesses because they're isolating him. The only thing that can really save him in regards to this matter is the attorneys. The attorneys can't, they're not able to meet with him. And if they do meet with him, it's not in privacy. That's crazy. Oh my gosh. Okay, so memorandum of law. So prison walls do not form a barrier separating prison inmates from the protections of the Constitution. Hence, for example, prisoners retain the constitutional right to petition the government for the redress of grievances. For instance, they are protected against invidious racial discrimination by the Equal Protection Clause of the 14th Amendment, and they enjoy the protections of due process. The Court of Appeals for the Eighth Circuit affirmed. Under the U.S. Supreme Court's holding in, there's a lot of typos in here. Regulations, conditions, and restrictions on jail inmates could be justified only if it furthers an important, a substantial governmental interest unrelated to the suppression of expression, and the limitation is no greater than necessary or essential to protect that interest. Because prisoners retain these rights, when a prison regulation or practice offends a fundamental constitutional guarantee, federal courts will discharge their duty to protect constitutional rights. For instance, correspondence regulations, that are unnecessarily broad, the court concluded because prison officials could effectively cope with the security problems raised by the inmate to inmate correspondence through less restrictive means, such as scanning the mail of potentially troublesome inmates. The district courts have also held that the correspondence regulation had been applied in an arbitrary and conspicuous manner. Prison walls do not form a barrier separating prison inmates, and it's just, why did they just do this again? I think they really just copied and paste at this point. Okay, several factors are relevant in determining the reasonableness of challenged prison regulations. First, there must be a valid, rational connection between the prison regulation and the legitimate governmental interests put forward to justify it. A second factor relevant in determining the reasonableness of prison restrictions is whether there are alternative means of exercising the right that remain open to prison inmates. A third consideration is the impact accommodation of the asserted constitutional right will have on guards and other inmates and on the allocation of prison resources generally. Finally, the absence of ready alternatives is evidence of the reasonableness of prison regulation. Let's see. I'm just going to get down to his part. The respondent's outrageous interference in the petitioner's right to counsel and his ability to prepare his legal defense violates the United States Constitution because he has a right to counsel. Likewise, the respondent's isolation of of the petitioner and refusal to permit him to have contact with the outside world, including his mother and family for years, is inhumane and patently unconstitutional. I need to pull up the Constitution so you guys can see it. Now, this is what he's requesting. He respectfully requests that this court issue a writ of habeas corpus directing respondents to show cause, that means appear in court, and advise the judge why he should not be released from unlawful detention and grant such other reliefs as the court deems just and proper. Because of the abusive and outrageous violations of his rights guaranteed by the United States Constitution, coupled with the efforts by the state to delay his trial after years of custody, it is requested that this honorable court order the petitioner's immediate release from custody. I would have to agree. Trial court, they declared a mistrial. He continues to, and then they ended up appealing that, but he continues to be in jail since 2019. Y'all have not allowed him to make any phone calls. You isolate him, and no telling what else they are doing in this jail. People have already lied on him, and that was proven to be false, but yet the sheriff's department makes up this whole lie. In addition to the lie that one of the attorneys was helping him escape. That sounds a little bit, they were watching I was watching, I can't remember, it was on Tubi, and but it was actually a real case where one of the detention officers was having an affair with the incarcerated, and they ran away together. Long story short, she ended up getting unalived in the shootout. Wild. And that's what it seems as if the Broward County Sheriff's Office was trying to make it seem like they were trying to run away together. This is truly sad. So let me go to, let's see, what was it that his first, fifth, sixth, eighth, and 14th. All right, so let's see what we're gonna do here. I'm gonna pull up. I think we all know what the First Amendment is. That is the freedom freedom of speech. Fifth Amendment. I might just do another video on this one. Okay, and I'm gonna switch screens right quick. Usually I have my little notes, but I didn't do that today. All right, so here we have the Fifth Amendment of the United States Constitution, which protects citizens from a number of legal proceedings, including criminal and civil cases. So here, this is what we're looking for, due process. So his due process has been violated. What is due process? No one can be deprived of life, liberty, or property without due process of law. All right. So that is the Fifth Amendment. They also said the Sixth. All right. So our Sixth Amendment is in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which districts shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusations. So pretty much his trial is set for September 2025. So he has to sit in there until September of 2025. Doesn't have access to his attorney so he can even prepare for trial. So he's supposed to sit there and wait. And we already know exactly what they were talking about as far as how we're treating him. Eighth Amendment. Eighth Amendment of United States Constitution prohibits the use of excessive bail, fines, and cruel and unusual punishments. This is crazy. So this is cruel and unusual punishment, what they are doing to him right now. And I'm pretty sure they didn't even go into detail. When they go before the judge, I know that the his counsel is going to let these folks have it. Broward County should be ashamed of themselves. I want to see how to report. Let's see. I said the 4th. Let's see, the 14th. There we go. All right, 14th Amendment, it guarantees the rights and the liberties to all citizens, including formerly enslaved people. So we kind of figured that. But equal protection, due process, those are the main ones. So once again, he is not getting equal protection. He is not enjoying life, liberty. I know that he's in jail, but he's not being treated fairly at all. So that is why they included that in his writ of petition for habeas corpus. I do hope that justice is done with the quickness for him. If they declared a mistrial because the state messed up, why are y'all keeping this young man? And I know that it is a unaliving case, but at the end of the day, if you don't have the evidence, why is this man still in jail? Why is he still incarcerated? Oh, that's what I want to do. I want to see what Broward County Sheriff's Department look like. Yeah. I didn't know I didn't know they were like this. Hold on, we're gonna take it just a step back right quick so we can all look at Broward County. Hmm. Look at sheriff. Is this Doctor Gregory Tony? My. Let's see. He brings a wealth of experience, expertise, and knowledge to the Broward Sheriff's Office, cultivated from his long career serving in various law enforcement and public safety capacities. Throughout his career, he has led by an example and led tirelessly to fulfill his promise to keep our communities safe. He establishes his home in the Sunshine State when he moved to Florida to play football at FSU. Uh-huh. Let's see. He earned his doctorate in criminal justice. His doctoral dissertation is titled Measuring the Effectiveness of Crisis Intervention Training in Law Enforcement. Understanding the importance of mentoring future generations interested in criminal justice. Uh, y'all could look at this. I'm just phew, I'm surprised. I am that just blew my mind. If you know what I'm talking about, you know what I'm talking about. Um this is very, very interesting case. So to kind of sum it up, YMW Melly, as it stated in there, was arrested back in what was that, February 2019 for capital unaliving charges. Since then, he hasn't had access to anybody in the outside world other than his attorneys that barely get to see him. He hasn't had a phone call since 2019. They are isolating him. They are putting him in areas of the detention center where there are no other inmates. He didn't have a door in his cell. When they give him his hour to go outside, everybody else is coming inside. You make up a false narrative stating that his attorney and him was going to make a getaway for it. And that man that man pretty much stated that he was going to make something up. He was going to embarrass her. Y'all tell me what y'all think about that in these comments below. Like, this is wild. This is wild. Tell me what you think in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I'm out. Bye.